Right. Happy Monday, everybody. This is Gary Quackenbush. Good to have you along here on the Word on Wealth. We're so happy that you have joined us. Two things are going to happen today. One is about the half hour. We're going to do tax problem solving day, figuring out if you do have tax issues, whether you've got late filed tax returns, unfiled tax returns, audits, tax court work, those type of things. We're going to be talking to attorney Richard Mathurin from GQ Law, and he'll be on with us having a discussion about those things. And that's going to be right at the bottom of the hour. In the meantime, we are going to be talking about some things to do with estate planning. Okay, so I want to give you kind of the specific details. There's this thing called the Secure Act. The Secure, it's an acronym. It doesn't mean secure anything, in my opinion. It's kind of more unsecured, but the Secure Act. I want to go over how that affects you and your estate plan, your trust, and how money's going to end up getting to your kids under the Secure Act. But because that's a law that changed a lot of stuff in 2019, so that was 3 years ago, and under law timing, that is brand new, infantile or infant size, and we need to talk about that. Make sure your estate plan fits under the Secure Act, having to do with your retirement accounts. And then the other thing is that as I go through the estate planning process with so many people on a daily basis, I run into certain complications that we're not anticipating. A lot of people will call me and say, I'm price shopping. I want to know how much you charge. And it's, I mean, I guess that's kind of like calling a car dealership and saying, I want to know how much a car is. What kind of a car? I want a crossover. How much is a crossover? Well, what brand do you want? You know, how fast do you want it to go? How many people do you want it to haul? How long do you want it to last? What are you looking for as far as comfort? And all those are the questions that we run into with estate planning as well. It's not a one size fits all. It's not just a little boilerplate, click, click, merge here, done. There is a lot of that in estate planning. There has to be, because as we put together trusts and wills, we have specific paragraphs that we have put in the trusts. The way I do it is the specific paragraphs that I put in the trust are paragraphs that work. They've been tested under courts of law. They've been tested under the law itself. So we know they work. And those are things that when you have passed away and your trust document is now going to be in full force and effect and be doing its thing, it's going to do it right. It's going to do what you want it to do. And that's what we all want. We just want our estate plan to do what we want it to do. That's the bottom line. That's why you hire a professional, to make sure that your estate plan does exactly that, whatever you want it to do. Okay, let's start out with the Secure Act. Also, there are phone lines open. We've always got a line open, so you can give us a call at 888-344-1170, 888-344-1170. Give me a call here on the air. You can call and talk to Noah first, and he will put you through to me, and you can ask your questions regarding your estate plan during this first half-hour segment. I want to talk about the Secure Act. The Secure Act came into play at the very end of 2019, and the acronym has to do with securing every community with retirement. So that's kind of part of the acronym. All right. So the idea was to change up how we inherit retirement accounts and how people contribute money to retirement accounts. And when you figure out, or when you hear what the Secure Act did, it has nothing to do with being secure. It has to do with getting money out of your retirement account so that it gets put into the tax system, finds its way on your income tax return so you can pay taxes on it sooner than you would have under the old acts having to do with inherited retirement accounts. Inherited retirement accounts have always been different than the retirement account that you put away. The way typically the most common retirement plan is called a qualified plan. It's qualified under the Internal Revenue Code to qualify for certain tax treatment. The big tax treatment that everybody really likes is that when you put money away in a qualified plan, the money that you put away comes off of your tax return. So if I put in $6,000 into an IRA or a 401k or some other qualified retirement plan, then I go onto my tax. I tell my tax guy, I say, hey, Craig, I donated $6,000 to my own IRA. Take that off of my income tax return. And so he does. He makes a reduction. So that $6,000 that I put away in my retirement account, that money is not taxable money. It is out of my tax drawer. I'm not paying taxes on it. I will someday. I will when that money comes back out. My plan when I put that money away was if I do get to the point where I am where I need to take out that money for retirement, my income will probably be lower and I'll be able to take that money out. Well, because it's my money that I put away in that retirement account, I don't have to start drawing it out under the Secure Act. I don't have to start drawing it out until age 72. Okay, that's a good part of it because it used to be age 70 and a half. The Secure Act came and said, no, now it's 72. So that makes it so that I don't have to take out my required minimum distributions until 72, which is a good thing for me because I don't need to take my money out at 70 and a half. I'm not anticipating, so I can wait until 72. That's when we look at a chart and we decide how much money I have to take out every year. Okay, that's part of the Secure Act. The other thing, the good parts of the Secure Act is it made it so that if I wanted to, I could continue making contributions to my retirement plan until I'm age 72. So I can keep putting money away, tax deferred, until I'm the age that it says in the chart. And for me, it works out to 72. Those are good things. All right. Now, the other side, the flip side is if instead I am inheriting money. Okay. If I am inheriting money under the Secure Act, then when I receive an inheritance and it's an IRA or a 401k or a 403b or any qualified retirement plan, qualified under the Internal Revenue Code, like we just discussed, I, the recipient, I get an inherited IRA. I don't care what it is. If it's an IRA or 401k, it doesn't matter. It's considered an inherited IRA. The way Marty Schneider used to describe it is it's an individual retirement arrangement. It's not an account. It's an arrangement, individual retirement arrangement. That arrangement now gives me money as an inherited IRA, not my own IRA, not a spousal IRA, an inherited IRA. And what the government does is they look at it and say, aha, that money that you just inherited, instead of you taking it out over your lifetime, which would be normal for an IRA, it's an inherited IRA. You have to now take that money out of the IRA within 10 years, 10 years after the date of death. I don't have to touch it for 10 years. Okay. Which is one of the selling points of the Secure Act is, oh, you don't have any required minimum distributions of an inherited retirement account. Okay. An inherited IRA, no withdrawals that I have to make, but I have to pull it all out within 10 years. So I have the option of taking it out now, some later, spread it over 10 years, whatever my financial advisor is advising me to do. That's what I'm going to do. So under the Secure Act, it made it 10 years. So if you have a kid that inherits money from you and the kid's, 20 years old, he has to pull it out by the time he's 30, which is probably going to be in his highest earning years. And that's when he's got to pull the money out. So it's going to be a huge amount of money that he's going to have to pay. It's going to be the tax on it's going to go onto his income tax return. So if you left him $100,000, then he's got to pull out $10,000 a year. If he says, I don't want to pull any money, I don't need it. And then on the 10th year pulls out 100,000, that number goes onto his income tax return and he is in a higher income tax bracket as a result. So that's the big thing with the Secure Act. All right. How do we deal with that with an estate plan? With an estate plan, if the money is going to a beneficiary, we know it has to be pulled out in 10 years. So what if the beneficiary is 8? How do you pull it out in 10 years? Well, whoever the custodian of the child is going to have the responsibility of liquidating that money, taking it out of the IRA, putting it into a regular account as the child, over the next 10 years, right? So once the 10 years are up or once the kid is 18, then the child can just go and get the money themselves. They can take it all out. They can take it out before the 10 years, whatever. It's their money. They can spend it however they want. And that to me is terrifying. If I worked my entire life putting my retirement account away, which I have, I don't want my 18-year-old getting their hands on it. Okay. Not that I don't trust him or her. It's just that they're 18 and I don't trust him or her. That's just the bottom line. It's not a bad thing. It's not bad parenting that I can't trust them. It's just more money than they will have made in their life up to that point. So typically what happens is money that is inherited has no value because it just falls out of the sky and that money is going to be wasted. That's just the bottom line, folks. That's what we have to consider. So you can put together a living trust that is called a retirement protection trust. It protects that money so that the beneficiary can't go and get it and haul off with it at age 18 if you're already dead. Okay. It makes it so that the successor trustee that you have designated in your plan is the one that is managing that money and handling it and making sure the money comes out over the 10-year period of time required under the Secure Act. And they don't take the money out of the retirement account and just say, here you go, 20-year-old, have your money. They instead hold it in the trust account, in the trust that you have created, and that trust then distributes the money per your terms. You may give it to them at 21 or 25 or whatever. My preference is you give them, part of it at 25, part of it at 30, and the balance at age 35 or something, whatever you think works out. But the idea is you get a professional or a financially mature successor trustee who's pulling the money out of this account under the Secure Act and putting it into a trust account where your successor trustee has the control, not your kid, but the successor trustee. So that financially mature successor trustee will be managing the kid's money so that it doesn't get wasted. I mean, it's one of the best ways to go. That's in a living trust called a retirement protection trust. And that's something, if you're interested in it, we do them all the time. I love doing them. I love explaining the concept. I can draw it out in pictures or whatever, but call me and get that taken care of. Get a retirement protection trust so that under the Secure Act, your retirement is protected and it doesn't go to waste. This is Gary Quackenbush. Coming up next, some complications we've got to talk about, some things to avoid when you're doing your estate plan, right here on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush of GQ Law. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there and filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. gqlaw.com, 855-500-TRUST, gqlaw.com.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, gqlaw.com.
All right, welcome back. This is Gary Quackenbush here on The Word on Wealth. One thing I do want to follow up on is under the Secure Act, if you have a living trust and it is not a retirement protection trust, it doesn't work out, it doesn't have the right language under the Secure Act, which would have been language that would have been put in there potentially since, should have been put in there since 2019, you may need to reconsider having your trust updated. And you can do it by an amendment. So it doesn't always require that you do a whole new trust. I mean, it's not, throw it in the trash and start all over. It's an amendment, and the amendment could be all the whole trust or pieces of the trust or whatever. We've done, a lot of times you just add it in. There's some language that needs to be added so that the trustee has that additional set of instructions, guidelines, and legal authorizations so that they can manage your retirement accounts under the Secure Act. So there you go. That's how that works. Okay. So it can be amended. The next thing are some complications. What I can't say I'm troubled. I just see this a lot. So it drives me crazy. So I guess I'm troubled about this. Improper beneficiary designation. When you get a living trust and get it all set up, one of your first tasks as the new living trust holder, congratulations, by the way, is to go and make sure that you fix all of your beneficiary designations. And that means you're going to go, maybe you have life insurance, maybe you have a retirement account, maybe you have, checking accounts, investment accounts, and all that. Those are the things that we're talking about. If you have questions on this, by the way, I've got lines open. You can call me at 888-344-1170, 888-344-1170, and let's talk about your beneficiary designations and how to do that. So with a beneficiary designation, I just get really blown away by how sometimes it's done improperly. Number one, and this just, just came up just last week. Ask somebody, how, who's the beneficiary of your life insurance? Oh, my husband. Great. And what if your husband predeceases you or dies at the same time? Oh, then it goes to our grandchild. How old's your grandchild? My grandchild is 4. And we want to make sure that he is taken care of for the rest of his life. I said, well, a $500,000 policy to a 4-year-old, yeah, that's a big amount of money. Who's going to manage that money? Oh, I don't know. I said, well, I'll tell you, it's going to go to your grandchild's parents. Oh, no, no way. Not letting my grandchild's parents have that money. They are not good at handling money, especially a $500,000 life insurance policy. So we then talk about how you manage that. And you don't want the beneficiary of the life insurance to be the grandchild, because they just need to wait till they're 18. If you're already dead, they wait till they're 18. They contact the insurance company and say, hey, I'm the beneficiary. Where's my money? And they get a check. That's it. I mean, it's not hard. And the company doesn't say, what are you going to do with this money? Are you going to be good with this money? Are you going to buy a fancy car? What are you going to do? They don't care. It doesn't matter. That's not their job to care. Their job is you died. They're going to write a check and hand it to whoever you say. I say, make it so that the person that gets the money is the successor trustee of your living trust. That way, the insurance policy just says, when I die, give $500,000 or whatever the number is, give it to the successor trustee of my living trust. Okay, if my wife is still alive, that money is in the living trust and she has access to that money. So there you go. If my wife has already died, then that money is going to go to the living trust. So either way, life insurance should always go directly to your living trust. It doesn't go to the trust itself. It goes to the trustee of the trust. That's going to be something where you log in to your account and you try to do it online, or you have whoever the insurance person is that sold you the policy, or whoever the administrator is, you contact them and say, I have a living trust. I need this money. When I die, I want it to go into my living trust. And they have the format on how to do it. Why is it on my list of troubling things and complications? Is because it doesn't get done. Folks, this is important. Life insurance should go to the trust. Do not let it go to an underage child. Even if you thought, well, fine, I'm going to give it to my spouse. And then if she or he is already dead, then it's going to go to my children. Great. But what if one of your kids has passed away? On a beneficiary designation and life insurance, if you say it goes to my children, okay, that's fine, but you have to name them. And if one of them has died, then the other ones are going to get it. It's not going to go to your grandkids. So beneficiary designations have the limitation, trusts do not. Okay, that's number one. Number two is joint accounts. So let's talk about joint accounts. And this is something where I would appreciate it if you'd take some notes, because I talk about this a lot. And then I get the question even more often than a lot. Call me if you have questions on this, 888-344-1170. You can ask me right here on the air, 888-344-1170. Or you can go to my website to ask these questions. Go to GQ Law. That's my initials, right? GQ and then law, gqlaw.com. And there's a contact form. You can just fill it out and contact me, and then we'll get back to you. Or you just give us a call. 855-500-TRUST. Joint accounts. All right. Keep in mind that joint accounts, if there's money in a joint account, and so let's say I have a joint account with my wife and I die. Who owns the money? She does. Great. If I have a joint account with me and my wife, and for convenience, I put my son on there, and my wife and I both die, whose money is it? His. It's a joint account. Now, you're going to run into some issues where people say, well, it depends. You can kind of trace the money and see who put the money in there, but it's a joint account. The bank is going to look at it and they're going to say, okay, joint account. It used to have Gary and Cheryl and Matt, and now Gary and Cheryl are gone. So it's going to go to Matt, and the bank's going to write him a check. So whether you can trace it or track it or fight about it, whatever, the bank is just going to say, who's the surviving joint account holder, and give them the money. That's all their job is. That's all they're going to do. Their job is not to question. Their job is to do what the account says, and that is a joint account holder thing. Now, you could have an account that's not a joint account holder, but you can have somebody that's an authorized user. That works. Okay. Why do you have a joint account? I have a joint account because what I want is that in the event that I was injured, or my wife and I are both injured and I can't get to my money, but I need it because I need it for hospitalization or for whatever, because maybe it's not going to be a 1 week stay. Maybe it's going to be multiple months in the hospital. I don't know, or in a rehab or recovery center. I don't know, but somebody needs to take care of me. Somebody needs to pay money, and I want there to be instant availability. So that's why we do an account and give access to one of our kids, or you can do a joint account and have it so that your kid is joint, knowing that when you pass away, it's their money, and that's okay. But if you have them on a joint account and you know it's not too much money, if they happen to take it out of there unauthorized by you, that it's not going to be the end of the world. So if you can trust your kid and you put them on a joint account, sometimes that's a really good idea, especially as you get older and you figure, eventually I'm not gonna be able to write checks. I might as well put my kid on that account. Understanding that money could be theirs when you pass away. Okay. So if you got 5 kids and the rest of them are going to freak out about it because Susie's on the account and she's going to rip it off, well, then maybe come up with a different plan. That's how joint accounts work. So sometimes they're a good idea. Sometimes they're a bad idea. If it's a small amount of money, I have no objection to doing joint accounts. If you have more comments on this or questions, call us on the show right now, 888-344-1170, 888-344-1170. That's the answer to my question. Is it a good idea or bad? And my answer is depends. All right. The next issue that troubles me is not looking at your estate plan. When my listeners come into me for a free trust review, I look through the trust. I do it while you're here. I don't really have a lot of time to review it ahead of time. If you get it to me ahead of time, that's great. At least we can have a printed out copy ready for me to mark up. But when I review it, I'm trying to figure out what the trust does. And the way I like to do the review is I will tell you, here's what your trust will do. It'll do A, B, C, and D, and this person will be in charge until that person's in charge. And I talk it all through and I write it all down. And then I'll have my clients go, okay, that sounds good to me. But not uncommon for my client to go, wait a minute, that's not right. That's not what I intended to have happen. I thought it did this and this. And so we go through our little discussion there. And what the discussion ends up as is, if you really want it to do as you're describing, then we need to amend your trust. We need to fix it and make sure that it does what you want it to. Because my opinion, without asking you any questions, is I can tell what the trust is supposed to do because I'm used to reading them and I know what they're telling me. So that's the way I do an estate plan review, to make sure it complies with all the laws and that you got the stuff under the Secure Act, that you have your IRA protection trust, your retirement protection trust, and that you have your beneficiaries all taken care of, your successor trustees are all charged properly. And we look at your funding too and talk about, is your life insurance in there? How about your investment accounts? Those type of things. And we've talked about many times on this show about funding, like putting property in your trust, all that. You can go to my website, gqlaw.com, and you can go to my blog. And the blog has all these podcasts and actually rebroadcasts or copies, recordings of these radio shows. And we talk about funding. We do it a lot. And there's also articles on my website, and you can get my free book. The free book is called Living Trust Basics. You go to my website, gqlaw.com, GQ, like Gary Quackenbush, law.com. And there's some free books on there. Living Trust Basics is the one that is the most popular. Second most popular is Accidentally Self-Employed, for those of you that want to know the difference between a corporation and an LLC, and maybe you should be one or maybe not. That's what that book is designed for. They're short. They're only little 20-page books, 8.5 by 11. It's sent you as a PDF. It's kind of more like a research page. It's in an outline format, pretty easy to read. So you can go to my website, get those free books, Living Trust Basics, or you can do the one about corporations. There's one about tax bankruptcy. There's a bunch of stuff on there on my website, gqlaw.com. Go there, get my free books, ask for a free consultation. Let me review your estate plan, tell you what I think it says. And if you and I agree, we're on the same page, happy day. If it does not what you think it does, then maybe we need to talk about putting it together in a different way. maybe make some modifications or changes. Don't know. All right. Fourth thing we want to talk about is remarriage and blended families. If you have remarried, if you have a blended family, your standard family trust won't work. Okay. It may sound like it will, but if you look down the road and say, okay, what about first death? What about if the husband dies first? What about the wife dies first? What if they die at the same time? What about, ages of kids? What about guardian? All that stuff. Remarriages, blended families cannot get by with a standard trust, because after one of the spouses dies, the kids of that spouse are no longer related to the survivor. Got that? So mom dies, her kids are not related to the husband because the husband has his own kids. Likely, all the money that the couple has put together is going to go to the husband's kids because the wife's kids aren't going to care about the husband anymore. They're not going to have a relationship, etc. Remarriage, blended families, we really need to get something more sophisticated so that you are protected, whether it's going to be irrevocable or partially irrevocable or irrevocable based on stages. Let's talk about that. Call me up, get on my calendar, 855-500-TRUST, 855-500-TRUST. Let's figure it out and make sure you got your trust and everything in order. Coming up next, Rich Mathurin, tax problem solving right here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500.
You're live. All right. Welcome back to The Word on Wealth, everybody. Happy Monday. I've got Rich Mathurin here in studio with me. So we are now going to, we're going to switch to tax problem solving. But first, we have Lori that's called in to ask a question. Lori, how you doing? Welcome to The Word on Wealth.
Hi there. I'm married. We have joint accounts on everything. And I was confused about having, say, we own a couple of properties, putting those properties in the trust that we have at this point. Mm-hmm. Since we're both alive, do I need to bother to do that? Because there would be one survivor, probably, most likely. Do I need to put it in the trust now, even though there's the two of us?
No, you're talking about the joint accounts or the property?
Well, both, like banks or properties.
Yeah, I mean, real property for sure in the trust, absolutely, because the thing that the trust is doing is it's controlling the distribution after you pass away, or it's controlling how the property is handled if you became incapacitated. So with property, and the thing is, Lori, you don't know which one of you is going to die first, and you don't know if one of you will die first. So if you don't what I always want to do is get everything done up ahead of time. So it doesn't matter which one of you dies first, or if you die at the same time, rather than leave some work to do. So anything, any real property that you have, any house, anything that's worth over $60,000 in California, which is be everything, would be in that living trust. And then with your joint accounts, it's basically the same way. If I don't have a problem with you leaving like a checking account or a savings account outside of the trust, as long as it doesn't have much money in it. I mean, if you're getting, high numbers up there, 50, 60, $70,000, that's when you want to start putting that money into your trust. So what I think is a good plan is have some joint account outside of the trust, maybe your checking, your everyday checking, and then everything else inside of the trust. Does that make sense?
Okay. Yes, it does. And I also inherited money to me from my family, and I have it in right now in a separate checking account because I don't know what to do with it.
Okay.
But I do want it to be accessible to me only at this point, and I don't want to put it in the trust because then
then you kind of blended it together.
Yes.
Yeah. So depending on how much money it is, if you want to make sure that that's money that only you control, there are different ways of doing it. I mean, one way is to keep it in a bank account in your name only, and then have it so that on your death, it pays over to your husband, or on your death, it pays out to your kids. It just depends. It depends on how much money it is too, because if it's over,
well, it's about 400,000.
Okay. So that amount of money, and do you want it to go to your children, or where do you want that ultimately to be paid after?
I want it to go to my husband if I'm dying. I don't know about incapacitation, but I want him to get it, and then we have beneficiaries after successor trustees after if both of us are gone in the trust. But I just wasn't sure.
Yeah, if that size of an account, I always want those kind of things to be in the trust, even though, I mean, if it's a separate account, you can have your own separate bank account, and you can actually title, like you can get a bank account in the name of the trust where you're the only person that's the signer on that account, and still maintain it as separate if you wanted to. Because you could
have to be written into the trust somewhere.
Well, it depends on what you're going to do with the money, and we can get specifics if you wanted to call me and we could talk about it directly.
Okay.
But one option would be to put that money all in the trust, and just make sure that there'd be language in the trust that says the account at such and such an account is maintained as separate property. And really what you do with it is going to depend on what you want to have done after you pass away. Because if it's going to go to your kids and you and your husband have the same kids, then it doesn't really, blending it or putting it together in the trust, it may or may not bug you that happens. Some people want to keep it completely separate. Some people set up their own trust account separate just for that money. Another way is to have that account where specifically it says the beneficiary designation goes to the trustee of your joint trust. And then you can do a power of attorney that if you became incapacitated, your husband would have at least the ability to get into that money if needed to take care of you. So you might be able to do it with a power of attorney and with some type of a beneficiary designation.
So right now, just leaving it in the bank separately is okay then? As
long as it has the beneficiary designation
in my name,
set up.
it's in my name.
Okay. And then what about the beneficiary designation, like the pay on death? Because that's what you want to make sure of. Like what you do is you talk to the bank. If my husband's
still alive, or
if your husband's still alive, it'll go to him.
Mm-hmm.
Yeah. And then if he's
it's not, I haven't written up anything that it would, but would it automatically?
No. Well, it's your separate property, and that much money would go to probate, and the probate court would give. Well, first of all, I forgot to ask, how many kids do you have?
It's not our kids. It's just us two.
Okay. So you don't have any children?
Mm-mm.
Oh, okay. So then your separate property will go, okay, this is awful. Okay. Half of it would go to your husband and half of it would go to your family, which means it goes to your parents who are probably, if they're predeceased, then it's going to go to your siblings. And if you don't have any siblings, then it's going to go to your grandparents and your aunts and uncle. So with separate property, like inherited property, like you have, only half of it will go to your husband by probate law. The other half will go to your family and to your heirs.
Okay. Well, it sounds
Yeah.
like I need to talk about it some more.
Yeah, because and there's some really good ways to do
Sounds
it. I'd be happy to
complicated.
talk to you about. Yeah, it's
Okay.
yeah, without kids, you want to make sure that it's controlled exactly like you want it. And so we'll figure out with the beneficiary designation and then maybe how to work it through the trust. Yeah, but call me. I'm happy to
Okay.
set up. We'll do a
Okay,
free
thank you.
consultation. You bet. Thanks for calling, Lori.
All righty. Thank you.
All right. That was Lori from San Diego. Thanks for that great call. If you want to call in and be part of the show and ask me a question, and I got Rich Mathurin here too. He's our tax problem solving attorney here at GQ Law. The number to call on the air right now is 888-344-1170, 888-344-1170. Rich.
Hi, Gary. Just want to say I'm available to be adopted if Lori needs to have some children to give her money to. No, it's just joking.
That's right. So we do, as one of the services that we provide here is we have Rich available to inherit your money. That's funny. I know. Oh, but that's fun. That's fun. Okay. So we talk about, so we have Rich come on, basically to talk about what the heck do you do all day, Rich? And basically talk about what you do a little bit. What are some of the things that you run into kind of on a daily basis here, pulling stuff together for GQ Law?
I generally help clients with their tax issues, whether the IRS, the California State Franchise Tax Board, sometimes with the EDD, the Economic Development Department of California. And then also if the clients have really serious issues, sometimes help them with a filing of a bankruptcy. So a lot of different hats. I also have some background in small business services. So I help a lot of our clients with contract drafting, things like that. Draft a lot of the motions in the office. So wear a lot of different hats.
So he's a guy that does all, yeah, he's the one that does all the legal work around here, which I really appreciate. That way I can do my thing and he does his thing, and together we can help a lot of people. And one of the things that we deal with, I mean, I know there's kind of this funny saying that everybody says, oh, there's the only two certain things in your life are death and taxes. You know, now I think it was Ben Franklin that said that or something, or Thomas Jefferson, one of those big guys. But it's like, I have always, I mean, in my 30 years of practice, I said, well, one of those is true. There is certain death, and then taxes, not necessarily, because there are ways sometimes if you have a tax problem, a tax issue, you're going to pay taxes. But is the IRS always right? Do you always find out that the IRS is right?
No, they can be very incorrect in their analysis, and there are options when you disagree with their findings, and you can do appeals and tax court petitions and all the like, and we can help you with that.
So if you get somebody, I mean, I got a call from a family member of mine, and she said, "Oh my gosh, I just got a notice from the IRS, and it's this very nice notice saying, by the way, you've messed up your tax return, and we want to talk to you about it." It was, not quite like that, but that's basically how it went. And it was, it was something where I look at it and go, well, the IRS is just wrong. I mean, but they sent out this really nice letter. They explain things. They say the law is this and that and the other, and then I disagree with it. So let's say, for example, a client of ours or a listener, a client, whatever, gets a notice from the IRS, and it says, okay, we'd like to take a look at your tax returns for 19, 20, and 21. So give us a call, and we'd like to set up a time to review your tax returns. Is the IRS, I mean, that's an audit, we know, right? When the IRS does an audit, are they always right? Should we just kind of go, oh gosh, just whatever you guys say?
No, definitely. I would make sure that you have your tax preparer, enrolled agent with you, or your lawyer there to kind of go through what the IRS findings are. And, you can dispute it. You if you have receipts and backup for your position, you can argue that. Generally, you would appeal any findings that they have. Mm-hmm. And then through the appeals process, you can submit your documentation to them. And a lot of times we've had good luck in getting them to overturn their original decisions, and maybe they settle for a lot less tax than they're asking for initially. Sometimes we have gotten audits totally reversed.
And it seems like too, if you know what you're doing and you're working with the IRS, there are different levels of appeal. Have you found then, like, let's say you go through the situation, you go through an audit, and whether you're at the end of the audit or the beginning of the audit, but sometimes there's a tax liability. Is the IRS willing ever to say, okay, we're going to waive the penalties? Are they ever willing to do that?
Well, they do have a program that is generally available to all taxpayers called the first time penalty abatement. As long as you did not have penalties in the 3 years prior to your initial getting penalties assessed against you, and you're making efforts to get into to pay your balance, whether through an installment agreement, offering compromise or the like, the IRS will waive that first time penalty. And it's sort of a misnomer because you can get multiple first time penalty abatements as long as you pass those, the 3 year rule for each time that the penalties are assessed.
So the first time in 3 years, basically, penalty abatement. And then sometimes in audit, I know that you're working on one in particular where the numbers get kind of large, and the IRS, a lot of times they'll consider like, okay, there's penalties for late filing, there's penalties for understatement of income, there's penalties for overstating your deductions. And yet when you get some of these deals that you're working with the IRS, maybe the client really was wrong. Maybe the deductions were, maybe we just couldn't prove them. Maybe the law kind of wasn't on our side. But then sometimes I understand is they'll actually look at it and say, well, you were wrong on the numbers, but it wasn't like intentional. So we're going to go ahead and back off on the penalties.
Yes, you can through the appeals officer that you work with does have the power to, negotiate on those penalties and interest. And I have had cases where, we settle for some point in the middle and can get the interest and penalties waived in that settlement negotiation.
That would seem like a big deal because penalties and interest get so high. I think that's what people really get annoyed about. Penalties and interest are so dang high. So it's always nice to have that. Well, it's always good to know that we've got Rich here. We're going to, coming up next, we're going to talk about a few options that'll be, if you do owe money to the IRS, what do you do? Do you just like run away and hide? Do you stick your head in the ground? Maybe not, but we're going to talk about that when we get back here on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to The Word on Wealth with Gary Quackenbush of GQ Law. We're here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the
Frank from San Diego's got a question.
855-500-TRUST.
We're with
Frank from San Diego.
Okay. Source for cybersecurity. And Craig, why would someone need 24/7 monitoring if they could just get cyber insurance?
Well, cyber insurance offers some valuable protection for you and your business. But just to qualify for that cyber insurance, you need to be watching your network 24/7. And you need to demonstrate to insurers that you have the software and the services that really do monitor your network.
So how could you help?
Well, our team at Borderland provides affordable and effective software systems that will address this 24/7 network monitoring requirement and make sure that you check all the boxes to get cyber insurance.
Reach out to Borderland right now at 855-945-8100. Get a free consultation and a quick quote on software services that help protect you and your small business and complies with insurance requirements. That's Borderland at 855-945-8100.
We look forward to protecting you.
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
You're live.
Right, here you are on The Word on Wealth. You got Gary Quackenbush and Rich Mathurin. Hey, Rich, thanks for being on the show.
Great to be here, Gary.
All right, so we've got a caller, Frank from San Diego. Welcome to Word on Wealth. You got Gary Quackenbush and Rich Mathurin.
Hi there. My significant other passed away in June.
Oh, I'm sorry to hear that.
Thank you. And she wasn't wealthy. She didn't make enough to pay taxes, so there's no. We didn't have to worry about probate. Her will, unfortunately, said nothing about the debt of the decedent being paid. It just talks about taxes. Any taxes do have to be paid. There's nothing about any other debts. And meanwhile, she had a checking and savings account, which she left to a charity by way of pay on death beneficiary provisions. And she has about $10,000 in debts. And the charity says, or the bank says the bank accounts, since they're going to this charity, are not part of the estate. And as it stands right now, we have no way to pay those debts.
Now, Frank, I'm really sorry to hear that. That's awful, tough to deal with. And I guess you've been dealing with now. So she passed this last June, like as in last month?
Yeah, June 9th, June 7th.
Wow, sorry to hear that. Creditors, the way it works is that creditors can try to get repayment from the decedent's estate. So whatever money she actually had after she passed away. Now, what I mean by that is, to clarify, is if there is like an operation or a function on that bank account that makes the money actually go away by contract at death, it's no longer in her estate. So the money that went to the charity, because it was a pay on death, their instructions were, once they determined that she'd passed away, they just would give the money to the charity. That isn't part of her estate. That literally flips out of her estate and goes and gets paid to the charity without paying that debt. So with the debts, though, are you joint on those debts, or is it just hers?
No, it's hers. By the way, the charity is not collected yet. Everything's kind of in limbo.
Yeah, it will go to the charity. It doesn't need to go to the creditor. And the creditor, I mean, the creditor will just go away. There's no money for them to collect. So what you're going to end up doing is telling the creditor, you provide a death certificate once you get it, and you just show them there's just nothing. There is no money. And creditors just go away. I mean, they're usually not terrible about it. I mean, if they tried to sue, they can't sue her because she's no longer here. And so for them to try to collect the money, what you're going to just do is just say that she's passed and there was no money. And sometimes they say, well, prove to us there was no money. Well, there was just no money. They can't prove otherwise. They can't prove there was any money, because if they do a title search, are they going to find any real property? Are they going to find anything that's a public record? Probably not. So the creditor will just go away.
Best we can hope for is to get sympathy from the charity and have them kick in to cover these bills. They would still get 2/3 of her estate, even if they coughed up voluntarily 10 grand to cover her debts. So they'd still be getting the bulk of the estate.
Okay.
So we might have to sweet talk them into that.
Well, but understand though, Frank, is it once your significant other passed away, the money, it's owed by her estate. It's not, I mean, they don't have to be paid. The creditor can't collect that money. They're just going to go away. And so the creditor's not going to have to come up with that money. If there were other like final expenses to take care of, final arrangements and all that you had to pay money for, that might be the thing to negotiate with the charity so that you can get reimbursed for some of those expenses. But they don't have to pay the creditor. The money goes to the charity on death. And that's, if they want to help pay for final expenses, that's one thing, but there's no legal obligation for those creditors to even be paid. So
it wouldn't matter even if the will mentioned debts of the decedent had to be paid first.
No,
because the bank accounts are not in the estate.
Not in the estate, no longer. After she passed away, they went away because they had a pay on death designation on that bank account. If it weren't for that, they would be in her estate, and then the creditor would have to get paid. But on the pay on death, it just automatically, by operation of that contract, it just goes out of the estate to the charity. Now, I know it's still sitting there, but legally, the charity is just waiting to collect on it.
Right.
All right.
All right.
So
thank you for your opinions.
You're welcome. You're welcome. Thanks for calling. Appreciate you being listening to the show, and good luck with that, Frank. Sorry to hear about your significant other. All right, you guys, wrapping up here on the Word on Wealth. Just as far as tax problem solving day, we've had a great day talking about estate planning and stuff. We're going to be back next week. Rich is here to answer your questions. 855-500-TRUST, 855-500-TRUST. Any tax problems you have, any issues with that, give us a call. Talk to Rich about your tax problems, 855-500-TRUST here at GQ Law. You can also go to our website, gqlaw.com. All right, talk to you later tomorrow, everybody. Same time, same station. Talk to you tomorrow on The Word on Wealth. Bye, Rich.
Bye, Gary.
Tell a friend about the Word on Wealth, featured since 1995 with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help you preserve your family's financial future. The information you hear on The Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily